Yes, yeah, and I understand. I know if I think of a jury trial, that would be 25 plus years if I were to lose. That I understand. Um, I feel as if I don't have to go to that route, thinking I know I'm not gonna beat the case, but I feel my constitutional rights were violated.
This is the moment every defendant reaches sooner or later. He knows he's not beating the case, but he thinks a rights violation might be the escape hatch. Spoiler alert, that argument only
Rights were
works if
violated.
It was at this moment that he knew he fucked up.
Okay, so let me stop you there. Here's the thing. With drug cases, right? If your attorney wants to file a motion, the court will hear whatever motion they file. Now, in my experience as a defense attorney and prosecutor, with regards to drug cases, sometimes people complain because there was a search warrant. They say the search warrant was improper, right? So that's something maybe you can file a motion on. Sometimes you have people who maybe were driving a vehicle pulled over by the police, and you say the police never should have pulled me over. And I'm just speaking to you in layman's term. And that may be a reason, right? So those are usually the reasons for
Judge
people are
Boyd
saying
is doing something important here. She's explaining in plain English what real constitutional violations look like in drug cases. Not vibes, not feelings, motions, evidence, and
for people are saying my rights were violated. Now, drug cases normally, and yours normally, would probably be, what is this? A third-degree felony with a range of punishment of 2 to 10 years in prison. But if you are designated as a habitual and the state is able to prove up that you're habitual, now how do they prove that up? Usually, you know what it ends up being? They have somebody send what's called a PIN packet. And the PIN packet is a packet that has documents in it that will show that you were sent to prison or something before this case, right? So if that has happened twice before this case and the state is able to prove it, then that means you're designated as a habitual. The law changed back in the day. Didn't matter how many times you had been to prison, you wouldn't be designated as a habitual. But all around the country, they started doing this 3 strikes and you're out thing, right? So with you, instead of your range of punishment being 2 to 10 if you were found guilty, your range of punishment is a minimum of 25. So that means if you go to a jury, if a jury were to find you guilty, they can't give you probation if they find that these allegations are true. Your minimum is 25.
And here comes the hammer. Habitual offender status changes everything. This goes from a normal drug case to a mandatory 25-year minimum. Jury bench doesn't matter. There's no probation.
If you come to me for a bench trial, and what I can tell you, I've had bench trials before me where I found people guilty and I found people not guilty. If you come before me and you're found guilty on a bench trial, I can't give you probation. Your minimum is 25. And I know sometimes people are like, oh, it's just a drug case. I can't believe I'm getting 25. But that would be your range of punishment. It's completely up to you. So for your case, we'll set it for a jury trial.
Like I was gonna say, it says here that I was found with 1 gram. I had 3.2 grams.
Oh no! So here's the thing, and go over there.
A few moments later.
And
That shut up wasn't disrespect. That was damage control. Defendants talking freely in open court is how cases get worse, not better. Every word can lock you into a version of events.
you don't want to let or admit to things. You're not under oath, so you'll be fine. But this is what I can tell you about your case. Could I see the indictment on Andres Hernandez, please? They're putting you at a 3rd-degree felony because according to what I'm reading on the docket, it may be wrong. That's why I'm asking her to pull the indictment. You were in a drug-free zone.
That was on the sidewalk.
Yeah, here's the thing though, but drug-free zones, like schools are usually drug-free zones.
Yeah.
So if you're within a certain feet from a school, so that means that maybe if you have a possession less than a gram, it's no longer a possession less than a gram. They enhance it because you're in a drug-free zone. And when they enhance it, it becomes a 3rd degree. you become a habitual. Your minimum is 25. Now, if it's just a regular state jail felony drug case, then you're most likely looking at 2 to 20 years unless there's something else out there. So that's where we are.
So 10, that's so 44B doesn't work on this one either, right?
They're not, no.
Nothing like that, nothing like
No.
that. 44, nothing like that. Okay. Well, when they arrested me that day, it was San Antonio Independent School District Police. They called.
They're allowed to do
they
that.
called that San Antonio Police Department twice, and they never showed up. So they took me to their facilities, and they took my wallet from me. They took my credit card. They took my money, and they put it inside my backpack, and they kept it in their facility. And to this
You
day,
don't have it.
to this day, I'm unable to keep my money. I'm unable to keep my credit card because.
Okay, let me explain something to you, and I want you to internalize what I'm saying.
And I thought it was a violation of the 14th Amendment.
All right, I want you to internalize what I'm saying, right?
Yes.
I've had clients in the past before who have told me, like they get arrested for something. Let's say they get arrested for a drug case, right? And my client would tell me, hey, Stephanie, the officer roughed me up. My case should be dismissed. They think it means it's a wash. And I tell them, the fact that an officer maybe roughed you up, that is a whole different case. We're just here dealing with the criminal case. So the fact that you're saying that the school division, they kept your license, they kept your credit card, maybe they took some money, that's a civil matter. It has absolutely usually nothing to do with the
This is
criminal
where
case.
a lot of people get confused. Even if the police messed up with his property, that's a civil issue. It doesn't erase a criminal charge. Two different lanes. Two
Usually
different
nothing to
courts.
do with the criminal case. You understand?
Never in my rights either.
Yeah. So that's where we are. So if you want a jury trial, I'll give you a jury trial. I'm sure your attorneys explained to you. I've explained to you what a habitual means, and it appears in the indictment that I have that you've been designated by the state. They're saying you're a habitual offender. If you go to jury trial and are found guilty, you're looking at a minimum of 25.
Okay. Can I get PD trial?
I'm sorry?
PD trial.
Oh, sure. We'll get you your trial.
Judge, and for the record, the offer that I conveyed to my client was,
Oh, I don't need to know the offer. If you want to put the offer on the record, you can.
yes,
All right, just go ahead and go over there.
A few moments later.
And you're Mr. Hernandez?
Yes, ma'am.
All right, you've had a chance to have everything explained to you?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state needs to waive the habitual offender enhancement allegation.
Any objection?
And here's the
objection.
plot twist. The state drops the habitual enhancement. Suddenly, 25 years disappears. 2 years replaces it. This is why plea deals exist. Would you gamble on
Any
a jury?
objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
You're charged with possession of a controlled substance penalty group 1, less than 1 gram in a drug-free zone. The range of punishment is anywhere from 2 to 10 years.
Yes, Your Honor.
According to the plea, the state is proceeding on count 1, waiving the enhancement. They're asking that your punishment be assessed at 2 years in the prison. There's a $1,000 fine, and there are no applications. Is that correct?
Yes, Your Honor.
Any objection to the court changing the plea bargain paperwork to reflect that there are no applications?
No, Judge.
No, Judge.
Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just follow the plea agreement, Judge, and sentence my client to the agreed 2 years.
2.
2 years.
Yes. All right. The court will sentence you to 2 years at the prison, give you credit for any time served. There's a $1,000 fine, time and money to run concurrently. I'm going to request a therapeutic community for you. It's to help you with any type of drug addictions you may have. I do not have the authority to force them to place you in the program, but they'll see in the judgment that I'm requesting it for you, and you'll still need to request it. Do you understand?
Yes, correct, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. If you don't take care of this drug addiction you have, what's going to end up happening is you're going to end up in and out of prison. And if you have another charge, this may not be your attorney, I may not be the judge, this may not be the prosecutors. And your minimum sentence, depending on the type of felony it is, your minimum is 25 years in the prison. Now, so you're either going to end up in prison, or either last time you use may be the last time you use, and somebody may end up having to identify your body. I know you addressed an issue with me stating that the school police office or their security have certain items that belong to you. They should have turned that over to the police, but if they didn't, you are supposed to have those items back. So you'll need to contact them. I don't have any jurisdiction to force them with anything, okay? All right, good luck to you, sir.
Thank you, Judge.
Thank you. Who else is ready?